It has been more than 5 months now since a judge ruled the state cannot move forward with that billion-dollar-plus cap and tunnel for the Kensington Expressway, at least until more studies are done.
But that wasn't the only lawsuit over the expressway that was ongoing, and now community groups are appealing one of those cases that was dismissed. 2 on Your Side's Nate Benson is in the newsroom with the latest. Nate?
Yeah, good evening, Scott and Mary Alice. Just when I thought I was out, they pull me back in with another Kensington Expressway legal matter. All right, let me catch you up. Last year, there were multiple lawsuits filed in relation to the proposed $1.5 billion cap and tunnel project for the Kensington Expressway. In February, Judge Emilio Koliakovo granted a permanent injunction, which prevents the state DOT from moving forward with those plans until further environmental studies are completed. But one of those other lawsuits that were filed was dismissed by the judge, and it related to the public trust doctrine. In a nutshell, that doctrine
is the right of the public to its parkland cannot be taken away except by its representatives in the New York State Legislature.
Attorney Ellen Bozer argued that the State Department of Public Works, the predecessor of the DOT, did not have legislative permission to remove the Humboldt Parkway. However, Judge Koliakovo's decision in February stated, quote, that because Humboldt Parkway was a roadway, and since the legislature properly enacted a statute creating the Kensington Expressway, there can be no violation of the public trust doctrine.
We believe the court improperly dismissed that part of the lawsuit.
So Bozer and the East Side Parkways Coalition, along with residents of the Humboldt Parkway, filed an appeal with the 4th Appellate Division.
What we're asking for in the appeal is to put the lawsuit back in insofar as it seeks to force the state to restore Humboldt Parkway in Buffalo.
Bozer says that they're referencing the Small Parks Act passed in the state legislature in 1869. Which established the Humboldt Parkway and the Buffalo Park system as the precedent that the State Department of Public Works improperly removed the park for the expressway.
Only the New York State Legislature could determine to rip out that parkway and that parkland. In the 1960s, the New York State Legislature did not do that. Instead, the Commissioner of Transportation did it on his own.
While Bozer applauds that Judge Koliakovo ruled that the state needs to do the environmental impact statement, he says that the judge overlooked the facts that New York State established the Humboldt Parkway as a park, first and foremost.
It's a very important point because the New York Legislature did this and only the New York Legislature could undo it.
So what's the state DOT think about all of this? As they often say in situations like this, the department cannot comment on pending litigation. On Your Side, Nate Benson, Channel 2 News.